R.V. Easwar, Rama Subramanian Venkateswar. Educational qualifications include Bachelor of Commerce, LLM, and he also qualified as a chartered accountant. He enrolled as advocate on 9th July 1975 in the Madras High Court and practiced in several branches, mainly income tax, sales tax, FERA, revenue laws, matrimonial matters, company law in tribunals and high courts. He was appointed as the Vice President of ITAT in the year 2005, Senior Vice President of the ITAT in the year 2009, and the President of the ITAT in the year 2010. He functioned both as a single judge and as a part of division bench, and was a member of several committees during his illustrious tenure as a judge of Delhi High Court and retired in the year 2014. He was designated as a senior advocate by the Supreme Court in 2015, and at present he functions from Delhi, appearing before Supreme Court and doing arbitration work, advisory and opinions assignment. He has been panelist and speaker in many seminars and conferences all around the world. In October 2015, he was appointed by the Government of India as chairman of the 10-member committee constituted to make recommendations for simplification of the direct tax law provisions. So ladies and gentlemen, please welcome Justice Retired R.V. Easwar.
Ladies and gentlemen, please help me welcome Justice Retired R.V. Easwar as he speaks to us on international taxation, India's perspective. A huge round of applause, ladies and gentlemen.
Very good morning to all of you. Very happy to be here. It's my privilege. Frankly, I was surprised to be invited to such conferences, particularly in Dubai. I don't know, many of you may have heard this saying, to invite a person who is in the judiciary or the legal field to a professional body like the accountancy profession, I think it's a little, I felt, because as they say, law is at least 1 decade behind. Lawyers are 2 decades behind. Judges are 3 decades behind. So I was a lawyer, then a judge, and I have something to do with law, then I must be at least 6 decades behind. Something was said about my tax background, and it was said that nobody likes to pay taxes. There was at least one gentleman I know who liked to pay the taxes. I think it was Oliver Wendell Holmes, the famous judge of the United States Supreme Court, who said, I like to pay my taxes. Why? Because with taxes I buy civilization. Very profound statement. One word about the introduction which you gave about me. Mr. Subbarao said that his parents would have been very proud. Of course, my parents would have been very proud. But my wife would not have believed a single word about it. I'm happy she hasn't come here. Let me first of all thank you for giving me this opportunity to be present here this morning and for being able to take part in the proceedings on the subject international taxation and the India perspectives. It's very appropriate that this conference is being held in Dubai, one of the world's most prestigious commercial cities, a city which attracts tourists as well as investors. It is also appropriate that this is being held under the auspices of the Dubai chapter of the Institute of Chartered Accountants of India. As in my opinion, chartered accountants are the ones who are very closely associated to issues relating to international taxation generally and in other parts of the world, particularly in India, at least at the initial stages of the tax disputes. The lawyers take over later and you know what happens. Wherever investments, money and taxation are being talked about, I don't think chartered accountants can be far behind. I do not know how many of you know, I do have a chartered accountant's background. I am a chartered accountant also. Now that you have applauded me, I will also say I never practiced a single day as chartered accountant. All through I was a lawyer, a judge. But I come from a family of chartered accountants. I'm very proud to say that my father, who is now 91 years old, with me in Delhi, he has been a practicing chartered accountant right through from 1947. Probably one of the senior most, I think his number is 1453 or something. Then my younger brother is a chartered accountant who's practicing. My uncle is a chartered accountant. My brother-in-law is a chartered accountant. My brother-in-law's son is a chartered accountant. None of my two children is a chartered accountant. I said I didn't practice a single day as chartered accountant, but that was because I could go through the LLB examinations very easily. So I took to the legal profession first and took my own sweet time in passing the chartered accountant's course. I got enrolled in 1971 as an apprentice, as an article clerk, as they say. Took my CA degree in 1979 and the first attempt after my marriage. And a more serious note, let me share this with you. Your institute has been at the forefront of reforms everywhere. Reforms affecting the profession of accountancy, as well as in matters connecting accounting standards, concepts of accounting, accounting policies, as well as in the tax reforms. The institute has laid very solid foundations in these fields. It has had that sense of objectivity while recommending these reforms. I know as a fact that its pre-budget work in tandem with the tax officers of India has been much appreciated by successive finance ministers. Since the members of the institute know the pulse of the industry and the trade in India, and also in the entire world nowadays, their approach has been broad-based, and truly their work has been commendable. Even on the quasi-judicial side of both domestic as well as international taxation, the role of chartered accountants has come in for high praise. I am referring to those who have appeared before the Income Tax Appellate Tribunal in India. They must be knowing this. I am referring to their role as accountant members of this much acclaimed quasi-judicial body. Since I spent about 19 years in the Income Tax Appellate Tribunal, I have had the opportunity of looking from close quarters the type of work, the quality work which the accountant members have performed in the tribunal. Their acumen is not only about issues of accounting, but even in respect of legal issues, they are on par with the judicial members of the tribunal. And they deal with them very easily. If the Income Tax Appellate Tribunal in India has earned today a reputation of being a very fair and competent body deciding tax disputes without fear or favor and very objectively, I think I'm very proud to say, as a member of the Chartered Accountancy profession also, that the Chartered Accountant members can lay a considerable claim to have made their contribution to these factors that have elevated the Income Tax Tribunal to its premier position today. The conventional concept of tax is that it goes to augment the state revenues. It continues to perform that function even today. But when you speak of an international taxation regime, you actually speak of a treaty regime, what are called double tax avoidance agreements. The treaty regime has widened the scope of the functions of a tax. Strangely, one of the functions of the treaties is also to see that there is some foregoing of the tax by one country. The cross-border investments are looked upon as a source of employment in the target country and as providing an opportunity to revitalize local entrepreneurship. India, as a fast-growing economy, is now a priority for foreign investors. A double tax avoidance treaty involves some sacrifice of tax on the part of one country on the assumption, and a very fair assumption, that the investment more than compensates for the loss of tax by creating jobs, improving infrastructure and communication, and generally, and more importantly, fostering an industrial climate and culture. It is no longer a secret that one of the key issues faced in an international or cross-border transaction is that of double taxation, which arises due to overlap of two or more tax jurisdictions over the same transaction or income or asset. I am not addressing the question of double non-taxation. I am sure you all know there is a question of double non-taxation also. I am not touching upon that. There is always a conflict between the source jurisdiction and the residence jurisdiction when there is a cross-border international transaction. The double tax treaties normally find ways to eliminate double taxation by any one or a combination, you are all aware of that, of the following methods. The exemption method, which taxes only the domestic income. The deduction method, which allows full deduction for taxes paid in charging the taxable income in the country of residence. And lastly, the tax credit method, in which taxes paid overseas in respect of the income is allowed as a credit. That is no longer fashionable, though many of the DTAs still do consider some provision. Generally, it is avoidance. It's a matter of pride for me to say that in the matter of international taxation, the Income Tax Appellate Tribunal and the High Courts and Supreme Court of India have taken the lead in the matter of interpretation of double tax avoidance treaties. In India, the sheer number of disputes, I do not know whether you have an idea about this. Today, the pendency of tax disputes in the Income Tax Appellate Tribunal is 1.25 lakhs all over the country, of which at least 1/3 is about international tax. So you have about 40,000 appeals, and all these appeals are decided and they are taken up, some of them reach the Supreme Court. And so by the sheer numbers and the volume, every day there is some important ruling coming out of the tax tribunal or the High Court. The numbers themselves throw multifaceted challenges on nice questions of interpretation of treaties. And believe me, we have handled them very competently. We have in India a very professional and well-informed tax bar, which includes the chartered accountants also, whose contribution to the growth of international tax jurisprudence is awesome. They are up to date with the nuances and developments that take place globally, thorough about the business models. They have access to the latest literature coming from different parts of the world and are thus able to shape the growth and direction of the decisions. And again, I repeat, the role of chartered accountants in this field is very significant, particularly the youngsters who are increasingly taking to the subject of international taxation, as my experience in the recent past has shown. Frequently, there are comments heard in India and abroad also that the Indian domestic tax system is too complex and complicated to understand and apply. Albert Einstein is supposed to have said that the most difficult task he has ever faced is to fill up his income tax return. This he said about 60, 70 years back perhaps. Today, I don't think he will put pen on paper. Though there may be some merit in it, it's complicated. But there is also the other side of the story, and that is, if the business models are complex, then the tax laws have to be necessarily and matchingly complex. I'll explain. One would have never imagined a few decades back that the corporate structure could take such a complex and multi-layered form with or without tax objectives in mind. If the government thinks that because of such complexity there is a loss of revenue, then I think we must concede the right to the government to deal with it effectively, and if this gives rise to some complexity, it perhaps cannot be helped. Imagine a situation of, you all know about the Vodafone case, which everybody very fashionably speaks. What did they do? Such a kind of a layering and structuring. And you must have matching laws, which may be complex to deal with because of the complexity of the corporate structure. And you can't really blame the government. You can't really blame the act. It has to deal with complex situations, so it must have complex provisions. If we are not able to understand that, that's a different matter. But that is not to say that there is no room for efforts to make the tax laws simple and effective, a task which is easier said than done, and I know it. The Indian government has for this reason constituted a committee of which I am somehow the chairman of the committee. And we submitted the first report. And believe me, it is not simple to keep things simple. We had only 2 months' time for the first report. We did only simpler provisions. The rest is to come. The more complex provisions and the recommendations is yet to come. We are at it. But it's a matter of some satisfaction to me, at least personally, that many of our recommendations in the first report have been accepted either fully or substantially. Now, the Finance Act 2015 was the first major opportunity for the new ruling dispensation in India to prove its intentions regarding its approach to non-resident taxation. International taxation is essentially about non-resident taxation. It deals with other aspects also. Certain changes were made taking into account the criticism, which is not entirely unfounded, from international investors. These changes sought to ensure certainty and predictability in the tax regime. One of the first steps which the present government did was to constitute a committee under the stewardship of the former Chief Justice of the Madras and Delhi High Courts, Justice A.P. Shah, to examine the applicability of the minimum alternate tax provisions, you know the MAT provisions, to foreign international investors, FIIs, and foreign portfolio investors, FPIs. The question referred to the committee was whether the MAT provisions would apply to foreign companies. Now, under the Act, a company was defined as including a foreign company. So the problem arose. In a 66-page report, the issue was examined thoroughly, if I may say so with respect, and it was recommended by the committee that foreign companies were outside the scope of MAT. The constitution of the committee to examine controversial aspects of international taxation is a significant step in a sense that it is indicative of a very structured approach which the government proposes to take towards redressal of grievances and shows a refreshing change in its approach to similar situations in future. There is a slight difference here between the appointment of the earlier committees. It's not that the governments have not appointed committees. They have appointed committees and committees. Rajachalya Committee, Chokshi Committee, Shom Committee, and all that. But today there is a slight, there's not a slight, that's a major difference is a committee is being constituted for the purpose of specifically sorting out an issue, a controversy, just as the Shah Committee, where the government wanted to know whether it was really justified in invoking this act literally and saying that FIIs and FPIs have to pay MAT. It was only for the specific purpose the committee was constituted. Now, Income Tax Simplification Committee, which has been constituted, we have got 4 goals: certainty, predictability, ease of doing business, and reducing litigation. So the specific recommendations are only oriented towards these goals. And this is a new trend, and I think it's good. And if eminent judges are appointed as chairman of the committee, like the Shah Committee and all, they can address the questions quite comprehensively and come out with very acceptable solutions. And that trend appears to have started. Even in the case of controversial transfer pricing issues, again a burning issue. Today, in India, you ask any tax professional, especially youngster, it's very fashionable to say transfer pricing and international taxation, nothing else. In this issue, that is transfer pricing issues, the government last year made rules through delegated legislation. By delegated legislation, I think you all know, it's by way of rules and notifications, not by an act of parliament, in the areas of range concept, and to implement the use of multi-year data in the assessments. These are very significant steps. Again, in January this year, India signed 2 bilateral advanced pricing agreements. They're called APAs. They were signed with England, taking the number of such agreements to 41. We now have 41 agreements, APAs. A protocol was also signed to update the India-Armenia tax treaty, which provided for exchange of information between the 2 countries in the matter of banking and financial transactions. And you all know what happened with Cyprus. It has been, if I can use that expression, delisted because it did not honor the commitments under the treaty to furnish information. Some of the other significant steps that were taken by the government in the last year in the matter of international taxation were: 1, the signing of multilateral agreement on automatic exchange information, which is generally seen as a step in the right direction, a direction of implementing the best practices in the administration of tax regimes. We try to incorporate the best practices all over the world, how they could be incorporated in the international tax regime of India, particularly. This is a very good augur. And 2, laying down reporting requirements for financial institutions under the FATCA. You all know what is FATCA? Foreign Account Tax Compliance Act. And thus falling in line with the international tax compliance norms. In addition to these steps, India has participated and made significant contributions in international forums such as OECD, the ICC Tax Commission, and the World Trade Organization. India's status, you all must be aware, in the OECD is merely that of an observer. But in the matter of BEPS, that is Base Erosion Profit Sharing, BEPS as it is called, India was asked to join the proceedings of the OECD as an associate, which is an enhanced status, which gives it an opportunity to be on par with the other members of that organization and contribute to the project. On par, not exactly on par in the fullest sense of the term, but sufficiently on par that its views are respected. And BEPS is a very complicated subject. The seriousness with which India desires to improve its tax regime can further be gauged by the constitution of the Tax Policy Research Institute, TPRU, and the Tax Policy Council, TPC, whose task it is to ensure a consistent approach to taxation and legislative issues relating to international taxation. While the TPRU, that is the research unit, would carry out the research on an independent status, it's not bound by the policy of the government. The TPC is tasked with implementing the findings of the research unit based on the research. These are welcome steps in ensuring a very stable, structured, and scientific approach to the taxation regime with large scope to examine and re-examine the issues that arise at the ground level so that a practical, non-confrontationist or a conciliatory approach is adopted. And now to the very recent protocol which has been signed between India and Mauritius, which has given rise to some debate. This protocol withdraws in a phased manner the exemption for capital gains tax for investments routed through Mauritius. As I understand the protocol from news reports, frankly I have not seen the protocol as such. The investments made up to 31st of March 2017 will not be taxed to capital gains on their disposal, while investments made till 31st March 2019 will be subject to capital gains tax on their disposal at half the rate, and investments made thereafter, after 31st March 2019, will be taxed at the full rate for capital gains. The rationale, in the words of the Finance Minister, Mr. Jaitley, is that investors making money in India must pay Indian taxes. Absolutely fair. The protocol was in the air for about 10 years and is now a reality. The impact has been softened by a phased manner of taxation, and the Finance Minister said that this is made to avoid the shock. Even this is a very right step. He has very optimistically stated that this will not lead to any depletion of foreign direct investment into India. Only time will show if he is right or not. The protocol also seeks to ensure that the companies registered in Mauritius are not shell companies with just a postal address, by providing that they need to incur an expenditure of about 27 lakhs in a year to show that they really exist and they function. The protocol has been widely perceived as putting an end to speculation, and the phased manner of withdrawing the exemption to capital gains is also seen as a relief as well as a shock absorbent. It is also seen as being consistent with the BEPS project of the OECD, in which India is an associate. At any rate, now, after the signing of the protocol, the India-Mauritius protocol, there is certainty, clarity and predictability. A lot of speculation has been put to rest. And even if the costs are going to be higher for the foreign investors, they will at least know where they are. For all these 10 years, 8 to 10 years, they have been under considerable uncertainty. The fresh protocol with Mauritius has thrown up another question. I believe that in the Indo-Singapore Treaty, India-Singapore Treaty, also there is a provision, according to the 2005 protocol, that the benefit of capital gains not being taxed in India, where the transferor of the shares is a resident of Singapore, that benefit would be available only so long as such benefit is available to the Indo-Mauritius Treaty. There is a link between the Singapore Treaty and the Mauritius Treaty by virtue of the protocol entered into in 2005. Since there is no clause or saving made by the Singapore Protocol for grandfathering of the investments in the manner in which it is now made between India-Mauritius Protocol, concerns have been expressed in India and abroad as to what would happen after the protocol recently entered into with Mauritius. This is a matter which I am sure will engage the attention of the Indian government so that it can take appropriate national taxation, double tax avoidance and all that. Who had businesses in Sri Lanka, Ceylon those days, Singapore and Malaysia. Therefore, the double tax treaties that were referred to were with these countries. The treaty with Sri Lanka was fairly simple and uncomplicated and was confined mostly to double tax relief. They used to call it DATR those days. There was not much of a DATA. Avoidance treaties were very less. The treaty between India and Malaysia and Singapore came up before the Madras bench of the tribunal very frequently. And I don't know, you must all have heard about this leading judgment of the Supreme Court in a case called PVAL Kulandayan Chettiar, where the interstate relationship between the domestic law and the double tax avoidance treaty was explained in detail for the first time. The seeds of the Kulandayan Chettiar case were actually sown before the Madras bench of the tribunal. There was a special bench constituted in Madras to decide the issue as to if there is a conflict between the treaty and the act, which will prevail. The fundamental rules of treaty interpretation were laid down by the tribunal in that order, and it was this order which eventually went to the Supreme Court, and it was affirmed. The tribunal's view as to what is the interstate relationship between the domestic law and the treaty was affirmed by the Supreme Court. Incidentally, on a personal note, I had the privilege to assist my senior, who was one of the lead counsel in that case. We had not heard of OECD, BEPS, and all that. These are baffling abbreviations. And all we had was the knowledge of the fundamental rules of taxation with which we would try to unlock the treaties in juxtaposition with the domestic law. I also remember a very interesting debate which took place before the tribunal while arguing that case, where the expression may tax, whether it meant shall tax or it included may not tax. These are very nice questions, and it will embody the whole approach of the Indian judiciary, how seriously they took it to the question of international taxation. With the changing profile now of the law relating to international taxation, the tribunal has coped admirably well, and many of its orders have actually laid the foundations for further nuances in the hands of the high courts and Supreme Court. In the rather intricate subject of attribution of profits, force of attraction, non-discrimination, permanent establishment, and all these, it is the order of the tribunal that has set the trend, keeping tune with the developments globally in those subjects. The assistance which the orders of the tribunal has rendered in the field of international taxation to the High Courts and Supreme Court has to be acknowledged. There are several instances where the orders of the Income Tax Appellate Tribunal have been cited and read with considerable respect by the tribunals and courts all over the world. I am particularly proud of this as I had the privilege of participating in some of those orders. The accountancy profession must take a substantial part of the credit for such path-breaking orders, as many of them were written by members belonging to your profession. Now, if I am asked to mention one judgment of the Supreme Court of India in the field of international tax regime, more particularly in the interpretation of treaties and their legal status vis-à-vis the domestic law, I will unhesitatingly refer to the judgment of the Supreme Court in Azadi Bachao Andolan. I am sure you must have heard about this judgment. I am referring only to that part of the judgment which has laid down the fundamental rules of interpretation of treaties, the relevance and implications of Section 90, subsection 2 of the Income Tax Act, read with sections 4 and 5, the inter se relationship between the domestic law and double tax avoidance treaties, the implications of the power of the executive to enter into treaties, why are they binding, and all that. The first part of the judgment is entirely devoted, about 25 pages, to this. The other part deals with tax avoidance and all that. That's a different matter. A lot of clarity was thrown on these issues by the judgment, if I may say so with respect. Several other judgments have been rendered by the Supreme Court in the context of Section 195 of the Income Tax Act, which deals with deduction of tax on overseas remittances, indirect transfers, the very famous or infamous Vodafone case, where the need to look at and not look through multi-layered corporate structuring was decided. After the Supreme Court judgments, I will only highlight, before winding up, two recent judgments of the Delhi High Court. One on the interpretation of the non-discrimination clause. It's very difficult to deal with non-discrimination clauses. Those of you who have been in that field, you will realize. Particularly in that case, there was a non-discrimination clause between India and US, Article 26(3). This is one part of the, this is one judgment of the Delhi High Court. There is another judgment of the Delhi High Court with which I will deal very briefly. The impact of the retrospective amendment to the domestic law on the treaty. Firstly, let me go to this non-discrimination clause. This was dealt with in the case of CIT versus Herbalife. It's a judgment delivered as recent as 13th May by a division bench consisting of Dr. Justice Muralidhar and Justice Vibhu Bakru. Here, Article 26(3) of the Indo-US Treaty, which provided for non-discrimination, fell for interpretation. The very brief facts I will tell you. The US company had an Indian subsidiary which was a company incorporated under the laws of India. The subsidiary in India made remittances to the parent company in US but failed to deduct tax thereon, and therefore you all know there is a provision in section 40 which says that if that expenditure is claimed as a deduction, if that payment is claimed as a deduction, and if you have not deducted tax thereon, it will not be allowed as a deduction. At that time, there was no requirement of deducting tax from such payments by a resident to another resident. This came in 2005. So they were on par from 2005. But this case before the Delhi High Court related to a case before 2005. So the payer company claimed that it cannot be discriminated against by making a disallowance of the payment, while there was no provision for disallowance if such payment was made to a resident. So it claimed non-discrimination. Here I think the specific language of the article became very significant. It said that the payment made by a resident of India to a resident of US will be allowed as if the payment was made under the same conditions to a resident of India. The court observed that what was of significance was not the requirement to deduct tax, but it is the consequence of the failure to deduct tax. According to the court, the prescription of different consequences depending upon whether the payment was made to a resident or to a non-resident would fall within the expression same conditions. What was being interpreted by the court was what is the import of the expression same conditions. To put it more clearly, according to the court, the consequences were not same and therefore there was discrimination. The Delhi High Court appears to have read the consequences of non-deduction of tax also as a component of the words same conditions. It would appear to be a kind of a mental gymnastics, but this is very real. The dispute is very real. I would, however, add a caveat here that it is because of the specific language of the article in the treaty that it was possible for the court to take the view. The court ultimately said there is discrimination because in the one case you are not disallowing, the other case you are disallowing, you are disallowing, and therefore this cannot be upheld. They said the payment made without deduction of tax to the US resident should also be allowed as a deduction. But I am doubtful if the same ratio can be applied to all treaties, regardless of the language of the article. And I do not know, I am not very sure, if similar language is employed in any other treaty. So one has to keep it in mind. It's for you to ponder over that question. You have also to ponder over the question, is the flip side I am pointing out to you, whether wherever the words same conditions occur, whether one can import the ratio of the judgment and claim the protection of non-discrimination clause on the footing that even the consequences of the failure to comply with the condition would fall within those words. You will keep in mind that the words same conditions qualify, that is in the Article 26 sub-article 3, only the deductibility of the payment and not the consequences of the failure to deduct. This can be one approach. What I am trying to tell you is an approach different from the approach of the High Court. The approach of the High Court was completely different. It said same conditions would also include the consequences of the failure to deduct tax. That could always be another counterpoint that it does not include. So I don't think the last word has been said, but this is a very important landmark in the interpretation of the non-discrimination clause, which in that case favored the assessee. It is for you are all tax pundits, to reflect upon this. And now the other and very much more important judgment to which I must refer is that of the Delhi High Court in New Skies Satellite and Shin Satellite Public Company, a judgment which was delivered on 8th of February this year. Very briefly put, the question was whether the beaming of signals from a transponder, which is about 36,000 kilometers above the surface of the earth, can be said to be a process so that the payment made to the owner of the transponder can be said to be royalty within the amended definition of royalty in the domestic law of India, that is the Income Tax Act 1961. The brief issue was like this. Payments were made to the transponder company. The transponder company said this payment is not royalty because there is no process involved. So it's not taxable. There is a definition of royalty in the double tax avoidance agreement concerned. There is a definition of royalty in the domestic law also in section 9 of the Indian Income Tax Act. Now the rulings were, up to the tribunal rulings were that it may fall or not fall under the domestic law, but that is not the issue. Even if it falls under the domestic law, the definition of royalty is different in the double tax agreement, and this payment doesn't fall under that. So very detailed orders were passed by special benches of the tribunal and all that. I also passed one of the leading orders and said that this is not taxable because of the DTA. Now this probably irritated the government. So in the Finance Act 2012, they said this has gone too far. So what they did, there is a difficulty in amending the treaty definition because the treaty is a bilateral document. Both the countries should agree. So what they went and did was to amend the definition of royalty in the Income Tax Act, domestic law, with a retrospective effect right from 1/4/1962, the day in which Income Tax Act 1961 was enacted. They did that, and according to them, that definition overrode the treaty provision, and therefore this payment was taxable right through. I think they said for the removal of doubts, it has always been, and this and that, all that language. Now, whether this can be done by the government was the question before the High Court. Answering the question in the negative, the court held in very felicitous language. I wish all of you, I don't have the time to read the entire judgment, but I wish all of you go through the way in which the thought, it's a very tricky legal concept, the way in which the thought has been expressed in very beautiful language by Justice Ravindra Bhatt, with whom I had the privilege of sharing the bench for a long time. I am not party to this judgment. This was as late as February 2016. I'll read snatches from those judgment just for 2-3 minutes. Justice Bhatt says, and I quote, "There are therefore two sets of circumstances. First, where there exists no definition of a word in the DTA, regard is to be had to the laws in force in the jurisdiction of the state called upon to interpret the word. But where there exists a definition of a term in the DTA, there is no need to refer to the laws in force in the contracting state, in this case the Income Tax Act, especially to deduce the meaning of the definition under the DTA and the ultimate tax liability of the income under the agreement. Parliament, supreme as it may be, is not equipped with the power to amend the treaty. It is certainly true that law laid down by the Parliament in our domestic context, even if it were to be in violation of the treaty, that is to be given effect to, but the state unilaterally seeks to amend the treaty through legislature, the situation becomes quite different. That being said, the amendment to a treaty is not on the same footing as an amendment to the law. The Parliament is simply not equipped with the power to amend, to change the terms of the treaty through domestic law. A treaty, to begin with, is not drafted by the Parliament. It is an act of the executive. Logically, therefore, the executive, here you can say Income Tax Department, cannot employ or take the assistance of an amendment in the domestic law of the country to imply an amendment to the treaty. This is what in effect he has said. I will not read the whole thing. It is fallacious to assume that any change made to domestic law to rectify a situation of mistaken interpretation can spontaneously further the Income Tax Department's case in an international treaty. It is imperative that such amendment is brought about in the treaty as well. This is what has been held. I think time is up. There are several judgments, give me 2 minutes. Several judgments of other high courts and the Delhi High Court itself, which have very elaborately dealt with complex issues relating to international taxation. But it is impossible to discuss with them within the time frame available to me. My appeal to you as tax professionals, in case you are all tax professionals or you deal with international taxation at some point of time in your career, is that in all your efforts to educate your clients or your employer or to contribute to the field in an academic discussion, you should always be rooted to the jurisprudence laid down by the Indian courts and the tribunal. The field of international taxation, sophisticated as it is, should imbibe the legal culture so that it is respected by jurists all over the world and stands on terra firma. Friends, I have now run out of ideas and also time. I am always willing to learn. I have spent quality time here learning all the time, sitting through the brilliant speech of Dr. Subbarao. Such conferences many a times and usually they expose my lack of knowledge. They proclaim to me how much I do not know. I always feel humbled, and today it has been no different experience. I thank the organizers of this conference for the opportunity to share what little I claim to know on the subject with you. I thank you for the patience and consideration and the hospitality and kindness shown to me. I really felt pampered. Thank you all and good day. Jai Hind.